expected, so please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome everybody. Thank you for coming. We'll go ahead and take attendance, please.
President Schaefer.
Here.
Vice President Reese.
Present.
Secretary Summers here. Treasury Hanser.
Present.
And Trustee McDonough.
Here.
Trustee Schultz.
Here.
And Trustee Whitney, currently absent on his way.
Okay, changes to the board agenda.
It's not a change to the agenda in front of you, but it's a change to the posted agenda, which we reposted this afternoon. Today, in reviewing the contents of the letter that's going to be presented to you tonight, it was determined that there's really nothing in it that requires a closed session, and so the decision was made to have the discussion in open session.
Okay, great, thank you. Board of Education matters. So, do you want to have Ron come up and talk first, or? Okay, I think so too. There he is.
So, we have with us tonight Ronald Ward of Barnum, and he would be able to speak to.
You can present first, but before we have discussion, we should.
Right. Can present kind of what he's bringing to you on the board, and then yes, Mary, our parliamentarian, is very right. Then we can do question, answer, and discussion after the motion's on the floor. So
I'd like to introduce Ryan DeWald here, DeWard, and he's going to kind of go from there.
Thank you. I appreciate the opportunity to address the board today. There are some things that I think we welcome the open session, and we can have a dialogue on these, and also bring some clarity to what you have before you. There were some issues, as we understand it, that arose at certain points in the community regarding particularly the independence of the investigation. And so what you have is a letter of understanding that Guidepost and Barnum jointly are submitting to you, and both parties have signed. Andy O'Connell, the president of Guidepost, has signed for Guidepost, and I've signed for Barnum, in which we attempt to address some of the issues that arose with regard to the contract that was entered into between Barnum and Guidepost as part of the engagement to do the work of the independent review. Just to give a little context here, when the independent review and Barnum was engaged, the way that it was going to occur at the request of the board was through an attorney-client privileged investigation review. And there were several reasons for that. I'm not going to get into attorney-client privilege here today, but I'll just say that one of the central reasons that was obvious to everyone was because there was pending civil litigation. And the hope was that the investigation could move forward unfettered and not be stymied by subpoenas and the like from civil litigation. And so that's why it was set up that way. And I think that was a good decision because we would face subpoenas because they would have been ineffective with the way the investigation was done. The engagement with Barnum included within it the indication that Barnum would be hiring Guidepost to work as part of the investigative team, ultimately to do the laboring, most of the laboring or on the investigation, and ultimately lead it. And that was done with a contract that between Barnum and Guidepost that was fairly bare bones, purposefully, has a lot of standard language in it, best practices language to protect privilege, and that's why that contract was written the way it was. It was with the authority of Tom Donnelly, indicating that the board had provided authority. It was signed on his behalf, principally for the reason of the board agreeing that it would have financial responsibility for Guidepost bills, invoices, and not Barnum. There's some other items in there as well that relate to the district. Most of those, again, are standard financial terms like indemnity and things of that matter. So that was how the board was involved with that contract. But it was a contract that essentially was just between, for the most part, in substantive terms between Barnum and Guidepost. And so this, what you have before you today is a letter of understanding, which we believe will clear up any issues that arose out of that contract. And in particular, what we'd like to stress is the independence of the review. The review has always been completely independent from the board and from the district. The board, as those of you who have been on the board since the beginning of the review, has never been briefed, has never been reported to, has never received information on the results of the investigation, on what the findings were, of where the progress was in terms of the findings. Never has that occurred. The only discussions with the board have been on legal issues that have been attorney-client protected that relate on subject matter to process, cooperation, documents, things of that nature. But it has always been independent. And very early on in the review, when the issue arose as the independence of Guidepost, there was a statement with the agreement of Barnum put out on Guidepost website that made clear that ultimately when a report was generated, that report would be in the control of Guidepost. That the language in the report, statements in the report would not be influenced by any other parties, whether it's the district, the board, or Barnum. And that was made. And we just clarified that in the understanding, the letter of understanding, which clarifies it's agreed that Guidepost will have control over the language, the conclusions, the contents of the report, the ultimate report, and without influence from Barnum, from the board, and from the district, and that's in there. We also understood that an issue arose in the community with regard to whether there would be more than one report. There's not going to be more than one report. This final report is, there's not going to be a report for the board and a report for the community. There's a single report. And as was said previously in the statement made by Guidepost near the beginning of the review, that report will be released to the board. This is at the board's direction, as you know. Will be released to the board and the public at the same time. There won't be one provided early to the board. It will be released at the same time. There's some other elements of the letter that I could handle in questions if you have them, but just generally an issue arose as we understand it, as to destruction or not maintaining certain records relevant or that occurred in the investigation, arose in the investigation. That's best practices, and so in this letter of understanding, we wanted to outline what Guidepost and Barnum intended to do in that regard. And it's common that the party doing the investigation would maintain interview memoranda that was put together as part of the investigation, would generally maintain for a period of time certain documents relative to the investigation. And we've set that forth here. But things that would not be maintained and won't be maintained are individual notes of investigators that nobody could really read or understand, would just give rise to issues that are unnecessary. The position of the investigator, those would not be maintained. Michigan Freedom of Information Act would not be maintained. And there are a number of documents that were received through cooperation with the prosecutor's office that we're very grateful for, and those are held subject to confidentiality agreement, so those would not be maintained either. And that's outlined in the letter. The final point I guess I would make here in connection with the letter is the date in which Guidepost has committed to issue the final report on or before. Every effort will be made to issue it before this date, but the date that Guidepost is indicating that they're comfortable is on or before October 30th of this year. And in that regard, it's just so important, given the importance of this to the community, to the families, to the district, that this report be done with the utmost respect, careful attention, and that it just not have mistakes from being rushed. And the investigations of this type often take over a year. There are literally tens of thousands of documents that are involved. There were well over 100 witnesses who were interviewed. Information was obtained, a great bulk of information from criminal investigations with a confidentiality agreement with the prosecutor's office that has huge volume. terms of evidence and documents, police reports, things of that nature. And then there's been the civil litigation in which we've had access to the depositions and the pleadings. There's hundreds of pages of depositions and testimony. So there's a lot of testimony, a lot of documents, a lot of synthesis that had to occur. There's a lot of review of policies, all of those things coming together, both before, at the time of the shooting, and after the response to the shooting, that have made this a complicated but yet doable investigation. Although it did take time, October 30 is the date that we're comfortable saying that is the date for sure it will be issued. Also, recently, the team received information, as many people saw on the news, about the Miller hearing. And we received that information, transcripts of the Miller hearing. We've also asked for additional information from the prosecutor's office that they've committed just today to gather and provide to us quickly. And we received fairly recently additional documents that were requested from the district. So there is materials that currently are being part of this and are being looked at and being fit into those conclusions and analysis. And finally, at the end, before the report's issued, because there was information that was obtained confidentially with agreement with the prosecutor's office, we are going to allow the opportunity for some review of the report before it's issued by the prosecutor, because to the extent that evidence is referenced, if it would cause some issue with a criminal prosecution, we want to give them the ability to tell us what that would be, to tell guideposts what that would be, and perhaps it can be modified in some way. Not the conclusions, but if there's a reference to evidence that is somehow, in their view, could give rise to issues in criminal prosecution, given their willingness to provide us with that information and the circumstances and the obligations we have in connection with our agreement, we need to allow that to occur. That can be done, we believe, fairly quickly, but it is something, too, that adds into this October 30 date as the date by which Guidepost is confident they can provide the report, if not before. So those are the comments I'd like to provide to you, and stand ready to answer questions you might have about these matters.
I have some questions.
We get to motion.
Oh, and I can do that.
Motion to consider the letter of understanding from Barnum LLP and Guidepost Solutions LLC as presented by Barnum.
Any discussion?
So I want to go back a little bit. On this letter, it says that the engagement agreement, which is the one signed by Guidepost, Barnum, and Tom Donnelly on behalf of the board.
Yes, this one.
Correct.
This one. Okay.
Yep. There was no vote on that, and the rest of the board hadn't seen it.
Are you talking about the one on May 24th? This one right here.
May 26, 2022.
The one that the Blakes gave to us.
Yes. I'm sorry, go ahead.
Okay. So could you explain to me, because it says in here that it was for the purpose of acknowledging the board's payment obligation, but there's approximately 12 instances where it says client agrees to, and the client being the Board of Education, and it is outside of strictly financial. And at the end, it also says it has been reviewed and its terms are agreed upon and accepted by yourself, Tom Donnelly, and Guidepost.
Yes.
But if that wasn't approved by the board, what does that mean?
Well, in terms of whether there's a meeting of the board, I'm not here to give legal opinions on that, but whether the effectiveness of having it signed with Tom Donnelly's authorization, what I would say to you is this ordinarily was an agreement between just Varnum and Guidepost, but in this situation, because of the financial considerations, there was a principal reason why it was requested that Tom Donnelly provide authorization to indicate that the board was in fact going to take care of terms of the agreement with Guidepost. Now, there are some other things, standard language, I would say, that do reference the client being Oxford School District, but I think most of those could be grouped under financial considerations like indemnification. There's a few other, fairly standard terms like no conflicts of interest, things of that nature. In terms of how the information about the contract, which ordinarily would be kept in the files just of Barnum as an attorney-client privilege document, the engagement with Guidepost. In terms of those, how that was conveyed, I don't feel I should get into that here to the extent that's attorney-client privilege communications. I will indicate, though, that there was authorization received in writing to sign on behalf of Mr. Donnelly, from Mr. Donnelly. There also, ultimately, it was decided by the district in an effort at transparency, again, to turn this contract over in response to Freedom of Information Act request. And so it was provided then from Barnum's files to the district. The district didn't have it, so the district had the ability to object. But in transparency, to turn it over. Because as I said, it's essentially a standard engagement that it was made very clear early on that Guidepost was going to have the final say on the report. And now we're making that even more clear in the letter of understanding. But if your question is it